Let's take a look at selecting to downsize. When decisions must be made as to which employees will be selected for termination, the main legal requirement in this regard is that the means of selecting individuals for downsizing must not be discriminatory. Determining whether a discharge is actually part of a reduction in force is not always straightforward. A workforce reduction situation occurs when business considerations cause an employer to eliminate one or more positions within the company. Determining whether a termination is part of a reduction in force matters because if it is, the fact necessitates a modification of the approach typically used in discriminatory discharge cases. Courts accept the general legitimacy of downsizing and the likelihood that many of those who are downsized will be older than age 40 simply because this group makes up a larger proportion of the workplace. A relatively heavy burden is placed on plaintiffs terminated in a reduction in force to establish a prima facie case of disparate treatment based on age. The first approach to defining a prima facie case is tailored to the typical situation where an employer claims that performance was a factor in selecting employees for downsizing. This approach asks whether any interference of age discrimination can be drawn from a comparison of the ages and relative performance levels of employees terminated with those retained. The second approach is a more general and can be used to analyze situations where, for example, some employees are given the option to transfer and others are not. In downsizing, the question is not why members of the group were discharged or whether they were meeting performance expectations, but whether the employees were selected for inclusion of the list for discharge because of their age. Although employers are free to downsize, they must be prepared to explain why particular individuals were selected for downsizing. Citing a reduction in force by itself is not sufficient to defeat a discrimination claim. In general, it makes both practical and legal sense to offer experienced employees the opportunity to retain employment. Employers should have a clear, objective criteria for deciding who to downsize. These criteria must not include age or any other protected class characteristic and should be applied consistently before the fact of termination.